we thought that as a tech trade association, we'd tackle this mythology of algorithms, this notion that algorithms that are used to determine what shows up in your Twitter feed or on the right side of a YouTube screen are some sort of magic that ought to render that law obsolete. I think Cox and Walden in our brief tried to demystify algorithms. They're just rules for the order in which content shows up, whether it's reverse chronological, or maybe it's based on topics that you've been following, what your friends like, or it could be completely random. In all cases, those are algorithms or rules. And Justice Kagan, in her discussion, said that 230 was written in the pre-algorithm era, the pre-algorithm period of time. And that's just not true. I had used Prodigy and CompuServe in the 1990s, and they would arrange the posts of users in reverse chronological order based on the topic that I was in, with breakouts for discussion threads. That was algorithmically dictated arrangement. So the authors of 230 and the industry that uses it really believe that a holding for Gonzalez is going to completely upturn Section 230, and I think most of the amicus briefs came to the same conclusion.
Thanks. Matt?
Hi, everyone. Great to be here. I have the luxury and burden of going last, whichever you choose to think of it as, so I can maybe say I kind of agree with everybody, at least in some parts of what they said. I'll try to talk about what we said ourselves before just getting into comparisons and the back and forth and the argument with the other briefs. But Steve did such a great job painting you a villain of the Wolf of Wall Street. I really want to use my Mandalorian joke. As a tech freedom advocate and a tech advocate, but also a civil rights and social justice advocate these days, I noticed that the first episode last week was called The Apostate. And so sometimes when I come to rooms like this and say, we believe in 230, Free Press still defends 230 and thinks it's important, we just want to strike a balance with it. You know, I feel like people on both sides are going to say, well, that's not quite good enough. But that's really where we found ourselves landing in this case. And I'll say very quickly, that's for a couple of reasons. I mean, I will go down the panel a bit. I don't really agree with Professor Franks that C2A is the most important part, but I also don't agree with Steve that C1 is somehow triumphant or the primary piece. I really do think that they both work together and that they aren't simply mirror images of each other or somehow reinforcing each other. I think they really are two protections. I said I wouldn't get into other people's briefs, but I do want to think one thing that people do is they try to read publisher back into C2A and almost try to tie them together too tightly when they really can be thought of as different protections for different kinds of activities. What we said in our brief, and I'll go back to Shane too, is that things that we don't find ourselves saying every day. I was in my closet listening to a Supreme Court argument. I don't find myself saying this every day. We tended to come down more with Justice Thomas and Josh Hawley, I think, at least in some respects. That is not a comfortable place for me, but it is, I think. I mean, hey, I'll admit it, but it's true. I mean, we actually did not take the question presented up. We did not talk about the recommendations, at least primarily, as our main focus. And so I know there was discussion about, well, that's not even what this case is about, but we really did, I think, come down where Alex and others came down and said it's not about the recommendations exclusively. I think there's a lot of similarities, although some differences too, between where we came out. And the reason I say closer to Thomas and Hawley is that we focused on distributor liability and not Stratton Oakmont, not Cubby and CompuServe, which I think are very interesting too, but back to the Zarin case and saying that no, in fact, even though there are opinions about this on all sides, and lots of discussion, not just in these briefs, but everywhere else you can find, that there is a way to distinguish, or at least a need to distinguish. I won't pretend the way is easy, but a need to distinguish between publisher liability and distributor liability, which comes with a higher bar. It's harder to be found liable for that. So there are arguments saying that's impossible. They're really the same thing, especially on the internet. I get those. I have a lot of sympathy for those, but we still decided to talk about finding the platforms liable only when they know that they're causing harm. Again, admit that there's lots of questions about how that test would be run, but we think that's where courts, and frankly, to stay on our lane and to finish here, I would probably prefer Congress to do that, but can Congress do anything in short order is a great question. So we think that thinking about that distributor liability concept and not tying, as I think Alex said, lack of protection to any time you use an algorithm, Steve was saying this too, to me that's a disaster if we say computers are illegal or somehow hard to use. But if we can look at what companies are doing and say, aha, here they knew about the harm and they exacerbated it, then that's where we think there has to be at least some test. What I said when I testified about this last year and got the honor of doing it with Professor Franks was that, yes, I'm concerned about innovation being harmed, and if 230 is weakened too much about frivolous lawsuits, and not just frivolous, malicious ones, people suing to take down opinions they don't like, That's a big concern. I don't know why I like this turn of phrase. It sounds kind of old-fashioned and appropriate to CompuServe and Prodigy. I said it's not, though, just in the courtroom where people are harmed or silenced. It's also in the chat room. And so we are thinking about the civil rights, social justice, racial justice, all sorts of impacts that people see when they have no recourse, when they are, in fact, shouted down online, and see the kinds of harms that I think Professor Franks and others have done a tremendous job studying and bringing into the light for all these years.
Thank you. So I think it was Justice Kagan who said we're not all internet experts during, it was kind of hard to tell because all the voices start to sound the same when you're listening to it. But I thought after they got through a bit of a rough start, it was a really interesting discussion. So I really appreciate hearing your takeaway from both Gonzalez and Tamna. So we're not going to just stick to, and if you want to respond to Steve, the mic's yours.
I do. One of the things that I think is so wonderful about the law is that even if a person was the sponsor of legislation to begin with, that doesn't commit all of us to whatever interpretation they think that they had. The words matter. The legislative history matters. The conversations, if you look at what Congress was discussing at the time when it was enacted, had everything to do with Good Samaritans, had everything to do with saying we want to provide incentives for platforms to actually do the right thing and make sure that they're not going to be chilled by lawsuits that will sue them for saying, hey, you took down my material. So I do think that it's wonderful that the law does not have to be subject to revisionist or self-serving interests of interpretations after the fact, but to look at what actually, to go back again to the Good Samaritan notion of this, which to relate to the questions that the court asked, especially Justice Jackson seemed to pick up on because she had really looked at the statute in context. Back to the parable, right, that the Good Samaritan is based on, just to make things very concrete, that you have someone who is beaten up by robbers, left by the side of the road. This is a parable in the Bible, and Jesus is talking about this is what it means to be a good neighbor. Not to beat up the guy, but so the robbers have left this guy in the ditch, and a priest comes by, sees that this person is in distress, but just passes on because it's not his responsibility. And a Levite does the same thing, and then this wonderful person known as the Samaritan comes by and gets down from his horse, takes care of this person's wounds, makes sure that he gets the assistance that he needs. Now, in a Good Samaritan statute, we're supposed to be celebrating the Good Samaritan who helps, right? Who didn't have an obligation, but who helps. Now, if we have an interpretation of C1 that says, yeah, you're going to get the same benefit and the same praise if you help, or if you're the priest or the Levite who just passed on by and didn't care. And we're actually going to add another person who comes on by, and I'm not just the priest or the Levite who's watching the guy just suffer, right? I'm going to stop and take pictures of the guy, and maybe I'll go through his pockets, right? And the interpretation of C1 that says that tech companies can do whatever they want is basically saying, yep, those people too should get immunity. They should get the gift of the Good Samaritan immunity, even though they stood by and did nothing, or they actually profited from the harm in some way by making it more visible. So this is what I think I was looking for in the Supreme Court arguments to see, will any justice recognize the complex relationship between C2 and C1? Will they talk about how if you read C1 in that sense of you can do whatever you want, essentially, with very few limitations, how that completely contradicts the notion of the incentive? Because if you get the same reward for doing bad as you do for getting good, I think everyone understands why that would completely undercut the incentive for doing good. And one of the amazing things about not only Justice Jackson picking up on that, but I think you also heard it from Justice Kagan and Justice Sotomayor, was that there's a real difference between immunity and liability. When you say that someone is immune from something, right, it's not the same thing as saying they're responsible. If we say that the priest and the Levite don't get Good Samaritan immunity, we're not saying the priest and the Levite are responsible for the guy in the ditch. And so this argument that somehow if you don't get immunity under the statute, you're responsible for what people said is simply not true. It means that you are, as a tech industry actor, the same as any person in this room who could get sued at any time if somebody chooses to sue them. So one of the things that I was really gratified to see some of the Supreme Court justices pick up on was there's a difference between absence of immunity and presence of liability. And this notion that then, secondly, right, the Google lawyer comes up and says, yes, but there's all this uncertainty. We don't know if we'll get sued, and there might be frivolous lawsuits. I think it was Justice Kagan a few times was saying every industry has to deal with the fact that there might be lawsuits, right? That's a thing that everyone does. So for 20 years, it's not the question today of why is it going to be such a dramatic or alarming thing if we change the status quo? The question really should be, why have we had such an alarming deferential and preferential treatment to the tech industry for 20 years? That's the problem. The status quo is the problem. And whatever hypothetical harms may come when tech actors actually have to think about whether or not their incentives need to be aligned, maybe towards preventing foreseeable harm, what we know is that for 20 years, more than 20 years, when they haven't had to worry about that, we've had the so-called classic moral hazard. Basically, whatever you want to do, however risky you want to be with your behavior, you will suffer none of the consequences, and you can fully externalize those negative consequences to other people. Because it's not like harm doesn't happen, it's just the question of who has to pay for it. And right now, it is private individuals who have to pay for it through whether it is a terrorist attack or whether it is a defamation campaign or whether it is non-consensual pornography or whether it is doxing or deepfakes or whatever the case may be. They're the ones who have to suffer from it, and they are prevented from even accessing justice to even get to the point of, let's say, discovery to see how much did this tech platform know, when did they know it, could have they prevented it, and are they making money from it? And so again, the question really should be, if we're finally picking up this question after more than 20 years of the tech industry dominating with its very self-interested interpretation of what the statute says, to now ask, what has happened? What did you get from an industry that was told you can commit all the harm you want and never have to pay for it, and you're going to get all these benefits from this, and the moment someone suggests that you have to have the same responsibilities as any other industry, you can throw up your hands and say, oh no, that'll be the end of the internet and the end of free speech.
Amen, amen, and amen. Because my mother said, whenever I hear somebody utter a prayer, I should say amen. So we've just heard a biblical reinterpretation of the law from the plaintiff's bar of Galilee. And I appreciate them advancing 2,000 years to visit our panel here today for State of the Net. Thankfully, only Justice Jackson, I think, picked up on Marianne's argument in those questions. No one else did. And I'm glad to see that that's not likely to be where this thing will head. Shane, I stole the mic, sorry, and I'm out of the way
Yeah.
from Alex. But when you asked about questions, which questions, we had assumed that Alito, Gorsuch, and Thomas would have been eager to trim what 230 applies to. They've written about it in the past. And Thomas, I guess given seniority, leapt in with the first question, which he rarely does. And he says, are you saying that YouTube, if it used a different algorithm than the one for cooking videos, or are they using the same algorithm across the board? So Justice Thomas seems to believe that algorithms that are based on your interests are extremely useful and benign. He also doubted that the word recommendation was a good fit for the mere arrangement of how content might show up in Twitter when you sign in or next to the screen on YouTube. Justice Barrett asked one of the most surprising questions. Near the end of it, she asked Schnapper, the attorney for Gonzalez, and he confirmed the theory of the case that would say that users, those of us in this room, we could be held liable for retweeting or liking other users' posts, because that is the same theory under which he says that YouTube creates new content when it puts up thumbnails and lists it to go along. So the questions are difficult to divine where they'll go in the ruling, but those are some of the biggest surprises to us.
I do wish I could have seen a skit from Saturday Night Live where they're trying to, the clerk is explaining to Thomas, and it's rice pilaf that sticks. I'm like, how many other times did they go through something and they're like, okay, that one, go with that one. So Matt, reclaiming your time. Sorry, not Matt,
yeah,
Alex.
Okay. Rice pilaf shouldn't stick if you stir it, right? Yeah.
Well, I want to jump in. Let me start by saying that I sympathize a lot with the concerns that Marianne has raised and has been at the forefront of raising for quite a long time in highlighting the costs of the way that these platforms have operated for a long time. I don't have a lot of sympathy for the platforms. I generally think that what motivates their conduct online is not the public interest, not a commitment to free speech, but is generally a commercial bottom line. They're companies after all, and that's not surprising, and that's not necessarily a bad thing. That's just the incentives of a company. But I do think it means that there's a special obligation on people who draft laws and people who interpret them to think about the public interest and whether it would be served by particular interpretations of the law. So I just want to put that out there because that's my starting point. My starting point is not that we ought to be concerned about the rights of the platforms. I think we ought to be concerned mostly about the rights of the users of the platforms, both those who use them for good purposes and and we ought to be concerned about those who exploit the platforms to cause harm, and it often doesn't even take exploitation of the platforms. Often it just takes using them as they were designed, which is as engines of amplifying sensationalist and provocative speech. I think we have to have all those considerations in mind. And I think that the concern that, or the line that Marianne has drawn between immunity and liability is a really important one to think through. Let me tell you why I'm not convinced that that line does enough work in the context of the Gonzalez case. My concern is that Section 230, I think, provides an important procedural protection against suit that makes it less costly for the companies. It makes it so that the companies don't have to decide in the context of any particular piece of user speech that's up, is it worth the cost to them of leaving it up, or should they just take it down because they generally don't care about any particular viewpoint expressed on their platforms. They generally don't care about any particular kind of speech. And as somebody who spent most of my career defending, unpopular views, I'm concerned about human rights advocates, dissidents, government employees who want to blow the whistle, who might, through their speech, create a dilemma for the platforms in deciding whether to leave that speech up or to take it down. And so to me, the distinction between immunity and liability really does matter, because one, I think, provides a greater procedural protection. And I think you could argue, I don't think it's unreasonable to argue that we'll go through a period of uncertainty, and after that, the rules will have become a little bit clearer. We'll all know a little bit more what the First Amendment means today. Section 230 has largely stymied development of First Amendment doctrine in the digital age because we haven't had to answer these questions because of 230. And maybe we'll have a period of 10 or 20 years where there'll be uncertainty. But I'm not sure that it's worth the cost of those 10 or 20 years, and I'm not sure that at the end of those 10 or 20 years, where we'll end up is actually a system where the protections of the First Amendment are clear enough that the platforms will not have the incentive to engage in collateral censorship, to make the decision that it's easier for them, for example, every time somebody makes an allegation that a head of a foreign state is a human rights persecutor, I think it'll be easier for the platforms to take that speech down. Every time somebody makes an allegation that their boss engaged in some kind of corrupt practice or harassing practice, it may be easier for the platforms, for Google, to decide that that's not going to be on the first page of the search results because that will be a potential source of liability. I worry about that, and I know there's I'm not saying, to my mind, this argument is not a trump card of the concerns and the arguments that Marianne is raising, but those are the reasons why, on balance, I think it's still worth preserving Section 230 as an important form of procedural protection for the platforms, even as we look for ways to hold them liable for what they do that goes beyond, as I think of it, the mere amplification of speech. So in that vein, what I'll say about the Gonzalez argument, what I found, surprising, maybe I was pleasantly surprised that the justices seemed to recognize that the question of what immunity for a speech intermediary should look like is a lot more complicated than they had perhaps, or some of them had perhaps realized when they were calling for challenges to the prevailing interpretation of Section 230. I'm not somebody who believes that we have to have a maximalist interpretation of 230 to preserve what we have online. I kind of think we should address these case by case. But I was heartened to see that the court recognized that the questions are complicated, and it's not easy to weed through these competing interpretations and be sure about what the internet is going to look like on the other end. And that, I think, is a reasonable argument for letting Congress act, although I appreciate Marianne's, I think, powerful point that we've had 26 years of this very broad interpretation of Section 230, and are we happy with it? And I think there is reason to criticize where we are now.
Okay, Matt, now it's your turn.
Okay. I'm not sure exactly where to go. I guess I'll start with a series of questions from the argument, and then maybe come back and talk about some of the great themes raised just there. I mean, what I was most interested in, and I was also, I'll admit, I was reading it since I wasn't in town that week, so they really do get all the pauses in there. It's a great read because they have a lot of ums and repetitions. I probably should have listened. But to me, the real trouble that Professor Schnapper had was in that question of, okay, how are we distinguishing between what is the content of the third party and what is the conduct of the platform? And I remember the series of questions about the thumbnails. I felt like there he was really trying to have it both ways in some senses. And the justices, I don't think that they were Yeah, nearly, as Alex said, I think they were actually quite aware of the need for sophistication, whether or not each of them brings that. You know, it's kind of, as I get older, maybe I have more sympathy for this. It's a cliche in DC, oh, the justices, what could they possibly know? But I think they actually brought a lot to the table. And it's not like they were completely ignorant. These are just hard questions. So I really do think that different ones of them came at him on that thumbnail question. I think it was Alito who said, are they publishers there of the thumbnail? And he said, yes. And that would, I think, for most people, trigger this kind of gotcha moment. Well, if they're publishers, they're not liable. But of course, as people have explained rightly, you can be liable for your own content, right? You can't be treated as a publisher of third-party content. So I think that's what he was trying to get to, is making that distinction between third-party content and your own speech or your own content. But he had a lot of trouble with that, drawing that line between, you know, he was like basically, well, if it's content from the video, then that's protected, that's covered by the statute. But if it's somehow, I don't know what, some kind of thumbnail that is divorced from the third-party content, I mean, that might be a thing. You know, I'm thinking about Justice Thomas and his commentary in the Malwarebytes case on Jones v. Dirty World. You know, you can imagine a website that does a lot more to say, hey, watch this thing, and it's not actually just a clip from the video. But as far as I'm aware, you know, YouTube is mostly like, here's what the creator gave us, and they put it out there. But yeah, if I have another minute, I'll just swing back and say, yeah, I don't know. I mean, the kinder, gentler Matt. This is my first panel in DC since I quit Twitter, and also the first one since I gave up caffeine, really. So I'm I hope I'm not less feisty or less alert, but I might be. I have lower blood pressure for at least 2 reasons. No, I mean, just trying to unite some of the themes again. I really do think, you know, I don't discard the Good Samaritan story because it's old. You know, I think there's a lot there, and especially as Professor Franks explains it, the difference between saying you're protected from liability for what the other person did, but you might still have a duty to help, or at least not to exacerbate the harm. And so that's where I do think, again, there's a lot of common ground, if not the same things that we're saying between me and Alex. It's like looking at that question of what does the platform do? This is where I think it has become somewhat untenable, even though I strongly believe that we need 230. And where I would disagree with Professor Franks a bit is to say that I think the internet is, if not unique, if not exceptional in a kind of exceptionalist sense, it is important. You know, we've had this law, we've had these structures to, if not eliminate, then to lower the barriers to third-party content, to have those platforms be able to host people's speech without having to go through a letter to the editor desk or a broadcaster or some other kind of, you know, we sometimes call these old gatekeepers and new gatekeepers in our space. So I think it is important, but where I think we have reached this untenable situation is if a platform actually can march into court and say, well, we knew about the harm, we did use an algorithm, which to me is more of an indicator of their knowledge rather than something I would hold them liable for. We monetized it, it continued, it persisted, but, you know, tough luck, we have nothing to do with it. You know, that to me is where I think Silicon Valley companies have gotten a lot of scoffs and stares from politicians and people watching and saying, really, is that the case? And that's not where every politician is. You know, some want them to leave more stuff up as long as they agree with what's being left up. They say, you know, don't take anything down. Other politicians say, take more down. So there's lots and lots of trade-offs and lots and lots of inconsistencies. But I do think that's where at least I came and our organization came to this view that we do need to look at 230 again. If you really do have the kind of like, well, tough luck, we actually made a lot of money off of this, but it's nothing to do with us. You can't hold us liable for anything. That's where I do think we have to take a second look.
So we're going to go to questions in about 5 minutes, just so you guys are ready, okay? So last question from me is, so where do you think we come out best for your perspective, the courts or Congress? I'll start with you, Marianne.
Both.
Okay.
But I do think it so much depends on who knows what this court is actually going to do with any of this information. I do think, as I say, that there was a welcome sophistication that you heard from some of the justices about how right before, you know, Kagan is probably always going to be remembered for the whole, we're not the you know, the experts on the internet in this room. Right before she said that, she said, why should this industry get a pass? Right? She at least understands that there is something very deferential going on here that is not necessarily justified. And I think that it's not clear how many of the justices care about that. But I do think it goes back to other points that have been raised here about, is the default state that we're in, the status quo, the neutral perspective? And I think that there's at least some suspicion on the part of the court that there's anything neutral about it. And I think everybody in this room should be suspicious of that, because it is odd that we're still acting like we don't know, right? That we haven't seen scandal after scandal after scandal when whistleblowers come forward, not because of, you know, lawsuits because they're blocked by 230, but when you have brave whistleblowers who say, you know what, actually Meta fully knew that when you do this to your algorithm, it actually makes people unhappier and it makes them angry, but it's also making us more profit. And so we're gonna do that, right? So any tweak that we're going to make things healthier or safer is not getting us as much money, so we are making the deliberate choice to choose profit over people, as the whistleblowers have been saying. We know that Twitter has released reports, transparency reports to their credit before the current regime, that actually showed that there is heavy prioritization of far-right content on Twitter. We know that these are not neutral decisions. The idea that because platforms may now have to take some kind of accountability for their actions might mean that they would suddenly become politicized or they might become too anodyne. That just seems very odd, because right now they are making very political choices about what they think is going to get them the most amount of money and which figures in the government they already want to collaborate with. The whole scandal of the Twitter files really wasn't about Biden or about Hunter's laptop. It was actually about Trump saying, hey, Twitter, I want you to do this thing, and then Twitter doing it. That's already happening. It's already happening with the extraordinary protections that this industry has, that Google and Facebook and others are handing over women's data to them so they can be prosecuted for abortions. That's happening with all of the protections they have right now. The status quo is they do what's going to make them the most amount of money and what will get them political favor. That is where things stand at the moment. So if there is some recognition of that on the part of the court, that seems like a crazy way to interpret Section 230, that would be nice to roll that back. But I do think Congress has got to play a role here to say there are things we can clarify because of the 20-odd years that have gone on with this really dysfunctional view of what it is that this industry should be able to be entitled to have. And that all of these things about the sky is going to fall, I just, 2 words for you, I guess this is 3, but Dominion versus Fox, right? In other words, every other industry, including, the news industry, can get sued. And I think most of us in this room would say that's a good thing. Now, the fact that Fox can get sued, does that mean that Fox has been for the last, I don't know, however long Fox has been around, that they've been really towing the line and being non-controversial because they might get sued? Or has it meant that they're going to do exactly what Fox News is going to do? And when we finally get discovery in cases like this and find out just how many people knew how many things at the Fox Corporation to deliberately promote the big lie, well, that's good that we know that, isn't it? Good as a public service and good that that lawsuit can go forward. Why should the tech industry be any different?
No, we're going to get there. I was going to say if Hunter Biden had just used a licensed repair shop, we may have this conversation a little later on, but go ahead, Alex.
Sure, okay, I just want to, just 2 observations before we get to questions. So one is on this question of why the industry should get a pass. This was actually something that was kind of a consistent theme of Justice Kagan's questioning through both arguments. In the Tomna case, which is about whether the platforms can be held liable for aiding and abetting terrorists when they have general awareness that terrorists are using their platforms. Justice Kagan's question was, why aren't you just like banks, and we hold banks, more or less strictly liable for providing services to terrorists or terrorist financiers? Why aren't they the same? And one thing that, I love Justice Kagan. I think she's, the savviest justice, the best writer on the court right now. But one thing that I wanted to scream into the microphone or into my headphones when I was listening was, because there are speech intermediaries. The reason why we think differently about these platforms is because they're speech intermediaries, and that doesn't answer all the questions. But I think it's different to say that a bank should be held liable for engaging with quote-unquote terrorist speech, to say that a speech intermediary should. And we often have different rules for speech intermediaries, including people, news organizations like Fox News, which benefit from the New York Times versus Sullivan standard, which is not available as a general matter to private corporations. Again, it doesn't answer all the questions, but I think it is a really important consideration as to how we think about the balance of the public interest in the free flow of information and the need for liability for when the conduct of the platforms exceeds what we think serves the public interest. So then to directly answer your question, Shane, courts or Congress, to my mind, I think Congress would make more sense. I think it's the words, the text of 230 provide a pretty kind of shallow foothold for courts that are trying to do nuanced work in changing the balance of liability that the platforms are exposed to while simultaneously preserving the public sphere. But a word of caution when it comes to Congress and Section 230 and generally. I think most of the conversation around Section 230 has been, and I would put Mary Ann's work as a really important exception to this, most of the conversation around Section 230 has not been very nuanced in thinking really carefully through what problem you're trying to address through amending Section 230 and what cost that might create for the users of these platforms. Because 230 reform comes up in a lot of different conversations. For the most part, amending 230, even if you got rid of it entirely, would not address the harms that a lot of people are really focused on. It would not address misinformation and disinformation. There, your problem is not 230, it's the First Amendment. It would not address anything except for narrow categories of speech for which publishers or speakers can be held liable. And those can be really important categories like defamation, like child sexual abuse material, like revenge pornography. Those are important categories. They're not going to solve this, many of the problems that people have been focused on since the 2016 election.
Steve.
Yeah, thanks, Shane. Just three quick things. As far as takeaways from Gonzalez, I came away worried that Justice Thomas might be setting the table by supporting broad protections in Gonzalez, supporting 230 in Gonzalez with one hand, and then with his other hand, when the net choice CCIA case has come before the court this fall, this is the cases where we sued Texas and Florida over their laws that would mandate the carriage of content. So is it possible that Justice Thomas and Gorsuch and Alito might say that we'll rule with Google and against Gonzalez and create protections? Oh, but next fall, we're going to force you to carry everything. All lawful but awful conduct through some common carrier scheme. And we had one indication of that last May in a dissent that Thomas, Alito, and Gorsuch wrote in the net choice CCIA win at the Supreme Court on our Texas lawsuit. And then I would also mention that in Tomina, I was very concerned that under a ruling for either party, that there seems to be an implicit admission that the government has to be trusted when it reports what it thinks is bad content that has to be taken down. The lawyers for both Twitter and Tomina said that an unsubstantiated notice from law enforcement about terrorist activities would confer legally chargeable knowledge under the terrorism laws. And if any justices had concerns about platforms taking censorship orders from the government, they didn't show it in the questions that we heard in Tomina. A platform might, under a ruling, have to heed all government warnings as they come in about terrorist speech. And look, law enforcement and other government actors, particularly around the world, abuse that power. It's the modus operandi of authoritarian regimes. The Turkish government is suppressing discussion of the earthquake response under the notion that it's disinformation. So I worry about that. And then finally, you asked about Congress. Now, I know, Shane, you said we stay in our swim lane, but I guess it's okay to warm up the pool a little bit for them.
Yep.
Okay, so if I warm up the pool, I'd say that Alex said, what is your aim for Congress? What is your aim? Well, if half of Congress says they want to twist 230 to get more content moderation, which is what the Democrats would like, and the other half of Congress wants to twist 230 so that there's less content moderation, then I don't know how those aims are reconcilable in Congress. Bad news is that they don't reconcile in the states. We have 26 states that go one way and 26 states that go the other, which is why we had to sue them.
All right. Matt.
I can think of some ways to warm up a pool, but most don't involve swimming. No, I mean, I think the reason it's tempting to say courts is that they will rule, or at least once the Supreme Court has taken a case, they will rule. And we all know that, Congress is very unlikely to get to the starting line sometimes, let alone the finish line. I still think, and especially going back to what I said about our brief and the distributor liability questions around Zarin, I think Congress is more promising. If anything is going to happen here, which I still think is an if, I would much prefer a scalpel to a sledgehammer. And so, again, to kind of get towards legislation, I mean, that's why we said when we testified last year, without fully endorsing it, but now it's been reintroduced, something like the PACT Act that would, again, not please everybody, but would take, I think, kind of a middle ground and say, okay, you can be charged with knowledge, not, as Steve is importantly saying, just based on some kind of law enforcement notice, but based on adjudication. That's going to be way too slow for a lot of plaintiffs, I get it. And yet having some kind of due process considerations that are built in there and trusting the judicial system to provide that kind of knowledge, I think is promising. But again, we didn't endorse the bill when it was out in the last Congress because I think there was work still to do. So I prefer Congress, but I certainly get why courts will rule. And just to finish on, two things. I agree. I don't think tech companies should get a pass. Our organization has done a lot to hold tech companies accountable for the last 5 to 10 years, I think. But I do think that without, again, being exceptional or completely different from other industries, it is different for the reasons Alex was teasing out. So I can definitely foresee, and that's kind of what tempted us into this case, some of the things that Steve is talking about. Those would be more our nightmare scenarios. You know, again, kind of reading neutrality into the statute. And again, just to go over one other tripwire, people will laugh at me when I say we don't want it to be neutral, because people know what we've done with telecom companies, right? We just don't think, unlike some conservatives, to the point that Steve is making, we don't think Facebook is a common carrier. We do think that broadband providers are. So that's a distinction that is not obvious to everybody, obviously subject to debate, but that's just where we happen to sit, and that's why we think it's important and vital that in that speech intermediary zone, not only do these platforms have the ability to leave up third-party speech, but they do have the ability to curate and moderate and take down harmful stuff so that we don't have the proliferation of lawful but awful that I think we would see even more of. Let's not forget we see plenty of it today, but we would see even more of if 230 were radically altered.
Fantastic. We have 12 minutes for questions. Please say your name and who you're with, and you'll be second, Baron, back in the front. Do you have a mic? Okay, we're good. We'll just speak out. Do you want me to repeat the question? Yeah, okay. Hi, yes.
Yeah. Hi, my name's Rebecca McKinnon.
Hello, Rebecca.
Wikimedia Foundation. Of course, we are the nonprofit that hosts Wikipedia and a number of other volunteer-run free knowledge projects with very specific purpose and no commercial motive. We will, of course, also be affected by the ruling in Gonzalez, and a strong ruling in favor of Gonzalez will make it very difficult for us to continue to enable volunteers to build an online encyclopedia according to the rules that they themselves have set for what is in fact reliable fact-based knowledge, and rules which they themselves enforce, not our staff, but volunteers. So the users are actually setting and enforcing the rules. Self-governing online community. I want to compliment this panel for a really, I think, high-level discussion, but my one concern is that you all have been saying the platforms as if it's one type of thing, when, of course, Wikipedia is a platform. You all have been saying the industry and generalizing about its intent and so on, without distinguishing between the behavior that we might want to punish or, hold accountable in some way, understandably, and the kind of internet we want to protect and build and have more of. And so I'm curious to hear from the panelists, just sort of based on your own positions, both are we likely to get a ruling that's going to take into account the fact that the platforms are more than just the big commercial targeted advertising driven types of platforms? And how do we ensure, or what advice would you be giving to the justices, especially for those of you who would like to see nuanced change? How do we ensure that you're not killing Wikipedia as a proxy for killing the ability of communities to self-govern on the internet?
Hey, just for sake of the recording for Jolly in the back, the question is about Wikimedia, so go ahead. Steve, you want to go first?
Yeah, I think that a ruling that suggests that when Wikipedia brings up a list in response to me looking for a term, if that suddenly creates defamation and liability, I see why it would cripple Wikipedia. If I go to Yelp and look for a restaurant nearby for an idea for dinner tonight, and Yelp brings up reviews, suddenly a ruling for Gonzalez means that Yelp gets sued for defamation if reviews are unduly negative. GoFundMe. Would GoFundMe mean that the platform is liable if people lied about the prospects for their investment? And then remember e-commerce. It's not talk about social media, but e-commerce. The platforms that peer-to-peer economy uses to be able to let individuals sell products or services to people around the world are items that are listed. They're listed in a recommendation in response to the interest that you just expressed. A ruling for Gonzalez says that now those platforms, that eBay, is going to be liable for product liability issues on anything that it happens to portray in a list. So Rebecca, I mean, we completely get it that this has broad implications. And I did hear Justice Kavanaugh and a few of the others in Gonzalez start to wonder about the implications to the economy of following the Biden administration's advice and saying that recommendations in feeds are not protected.
Go, Matt, sorry, just happened to notice you.
I'll try to keep this quick, but I think that's an excellent question. I do think that the justice seems sensitive to the notion that there's more here than just the big corporations, and that we're talking about a ruling that would affect the architecture of the internet, and that can mean both good things and bad things. But I do think there's an argument for saying that if the general notion, again, is the division between immunity and liability, one of the terrible things about the status quo is that if you are allowing bad actors to get all the same benefit as good ones, then you're putting good actors at a disadvantage, or at least you're not giving them the same boost. I would like to think that actually a rule that says let's change that and actually have it be more like let's reward the incentives to do good would actually mean that Wikimedia does better in some ways, and not just Wikimedia, but other actors that could enter the space if they weren't being crushed to death by Google or by some other major corporation. So I think that there's real reason to think that this would actually be beneficial. Not to say that there wouldn't be some cost, because there's cost to every legal regime, but if there's one that actually does reward the kinds of sites and the kinds of platforms that are trying to do good and are not simply trying to maximize profit, I really do think a better reading, closer cued to the text and history is actually going to be good for that as well.
Thank you. Matt?
Yeah, I mean, I don't know that I have a great answer other than to acknowledge how good the question is. I mean, I think it's important to, and thank you for the calling in on that. You know, I'm familiar with those arguments. I've made those arguments. I think they're true, that we can't think only about the big companies and not think about not just smaller companies, but very differently situated companies. I think, though, the converse is true, too, that, you know, we can't say, well, we would never find liability for YouTube in this circumstance because it might hurt other companies, too. I just want to make sure we're looking at the entire universe and not painting with too broad a brush on any part of it, painting on the universe. But yeah, I mean, I think that, you know, if I had to answer your question with the sort of guesswork about what the justices will do, I'm not the best Supreme Court observer. I would imagine, or at least hope for, a narrower ruling that accounts for the facts in this case and doesn't do more than that. But, you know, when you give it to 9 justices with very different views, nobody, including me, can guarantee that's what will happen. So I think it's an important question. That's where we wound up, you know, and it's not, again, I'll acknowledge that the way we phrase it is not easy, but we did not take up the Gonzalez position. We filed in support of neither party and, you know, have a different question presented, if you will, or a different theory that is, I don't think, going to be reached, but, you know, is certainly another basket of complicated issues for sure, too.
Did you want to? Okay. Baron?
Thanks, Baron Soka, Tech Freedom. Professor Franks has, of course, filed a brief in this case, and she says today, of course, she said in that brief, much of what she said there. She said here today that who knows what the court will do with any of this? Well, we know how the court will answer this question. Justice Kagan has said we're all textualists now. We know the court will focus on text, and you tried to do that, but most of what we heard today is not about text. It's consequentialist arguments about policy. So let's just talk about text for a minute, because that's what's going to actually resolve this case. Professor Franks claims that the term publisher means only to refer to defamation and like claims. But if that were true, why did Congress bother including subsection E, which says nothing in this section other than C2A, so it's clearly recognizing that C1 is different, shall be construed to impair or limit criminal law, intellectual property, privacy, and then, of course, recently, sex trafficking. If your view of the statute were correct, we wouldn't need that provision. There would be no purpose of that, because those things have nothing to do with defamation or like claims. So it's very clear from a textualist perspective that C1 has to refer to something far broader than what you claim. Yeah. We also know that publisher functions, the actual issue at Gonzalez, are broadly, because F4 defines one of the things that can make you an interactive computer service provider, being an access software provider, includes filtering, sorting, allowing, disallowing, picking, choosing, analyzing, and digesting content. And whether or not Google and Twitter are access software providers, we know that those are the kinds of things that are included in publisher functions that are protected for interactive computer service providers. Your argument also turns very heavily, if not entirely, on the use of the Good Samaritan heading in subsection C. That puts far too much weight on that heading. The Supreme Court has said that headings and titles are not meant to take the place of detailed provisions of text, nor are they necessarily designed to be a reference guide or a synopsis. At most, the court has said, they can shed light on some ambiguous word or phrase. Here, of course, we know why C1 is grouped under that term, because in the Prodigy case, treating Prodigy as the publisher of content created a terrible perverse incentive for a company that was trying to act as a good Samaritan. So Congress created three separate provisions that dealt with that problem in distinct ways. But you essentially are arguing that we should somehow move the good faith requirement of C2A into C1 as if it applies there. If that's what Congress had intended, Congress would have written that good faith requirement into C1, and it didn't do so. It put it only in one provision. It also treats C2.
Just in the interest of time, can I ask if there's a question? I mean, you're litigating this like you're at the Supreme Court. The court's going to answer this question for us. This panel doesn't need.
Concerned about the spread of misinformation, disinformation, and right-wing propaganda, and so on, so many people in this room. It's very striking, though, that you're making precisely the same argument that the Trump administration made. If it were the case that C2A were the only protection for content moderation, Republican state attorneys general would be able to argue in their litigation that providers were not removing content voluntarily, that they were being pressured to do so, or required on the opinions or whatever. We're not doing so in good faith, etc. Content moderation would never be resolved in lawsuits about that under motions to dismiss. Every single case would become a litigated question. So I simply submit that your arguments today, to court and textualist arguments, disposed of.
Okay, the case is submitted,
right.
counsel.
So, jolly note for the record that Alex is braver than Shane, and that would you like to respond to any of that?
I didn't actually hear a question, so I'll just.
Okay. It was, for those of you in the back of the room, see Barron later. He had some interesting points. And for those who, we are at time, and apologies to this side of the room. You, behave yourself over here. You're being loud. I can tell you're passionate about it. All right, so if you want to stay for the Congress side of this equation, keep your seat, because it's in the same room. And again, all of this is is available on video. So if you're not seeing something else that you want to see today, you can go home and watch it tonight. But please thank my panelists for a great discussion. Sorry.
Got to work on my expression.
the case that whether you absolutely think it should be revoked or you think Section 230 is the best thing since fried rice, those aren't necessarily the dichotomies that we deal with. So kind of go a little bit into like the bipartisanship that exists on both sides. Also show how actually some incremental reforms have worked and actually have gotten through Congress. So it's to say that something cannot be done is not factually accurate by just by virtue of the history of how the legislators have dealt with these issues. And just final points. So I guess the issues are really twofold as I see it. One is the question in C1, which you heard a lot about in the first panel, which is the judge-made immunity under C1, which kind of opened the floodgates for these tech platforms to be immune from virtually every type of civil action, which also in some parts of the country includes contract claims. The second is the censorship that you see in C2. So that's one thing where I can see the legislators trying to grapple with and trying to understand how best to reform it. The second thing that we should realize is that both sides see a problem here. And so we've already seen an example of that last Congress. We saw the introduction of the Earn It Act, where you have Senators Grassley and Graham pairing up with Senators Feinstein and Durbin to understand the implications that Section 230 immunity may have, or so-called immunity may have, towards the prevention of sex trafficking and what have you. The last of the points that I'd really like to bring home here is that incremental approaches have worked on the legislative side. So we saw that in Sesta Fosta, where there was actually a lot, although maybe some would disagree that it went far enough or not, or didn't, or would have blown up the internet. I think two things are actually true. There were some good things that happened out of the Sesta Fosta conversations, particularly as it relates to limiting the liability for actual harm victims of sex trafficking. I think the takedown of Backpage is one part of it. Also, the Doe v. Twitter case is another example of how legislators can help fix some of the questions that we have. And also, to make a clear point of this, the internet didn't break just because Sesta Fosta existed. So the last point is really, look, if I would like to see anything, I would like to see a targeted and incremental approach to any sort of reforms. I think that's how you have to get it done. You can't just. I think someone said this earlier in the early panel. Pick a goal, and I think that frankly, that's ultimately how it's going to work out. Where both sides of the aisle see issues of concentrated power over our information as an issue. I think that's fairly bipartisan. So I guess in my view, it's strong. You need strong bipartisan support, and incremental change will most likely be the winner at the end of the day.
All right, it's going down the line. Thank you for framing it. Now, that was a great framing. I don't have to go into some of the framing points I want to do because I agree with much of what was just said. For me, part of the conversation about Section 230, it's intentionally being pitted into binaries, and I just want to unpack a few of the binaries. That's my framing for the conversation. I really would like us to get to the point where this conversation can go beyond whether or not a platform should be responsible for third-party contact and really into what is platform behavior and how is that different from actual liability for third-party content. And so some of these binaries, if it's either you're gonna kill the internet, or you're gonna kill all the smaller companies, or if you do anything to touch 230, every single company is just gonna be bogged down in never-ending lawsuits. I think some of that is maybe true if we're talking about killing Section 230, but I think most people in this room understand that. I'm not going to speak on behalf of others, but I, for one, am certainly not speaking about killing Section 230 or keeping it as is. I want to talk about how do we update the law today to fit the reality of what the internet is right now. And some of that is about figuring out what is a company's behavior, especially, and I'll get into this later in this panel with some examples. I mean, if a company's behavior is actually enabling violation of civil rights laws, how is that not something we should consider? And that is very different from the defamation questions or the questions of third-party speech. So what I would like to see Congress actually ask And again, also, sorry, the Democrats versus Republicans. Democrats want to take more content down. Republicans want to take more content up. That's actually really just focusing on content moderation, right? And I would like to focus the conversation on behavior and conduct of the actual companies versus content moderation. What I would like to see Congress consider and really talk about is where should Section 230 protections stop? Where are the lines? And I don't just mean the word algorithms, because that's like become this whole thing of, but algorithms run the internet. But what are the lines? Are the lines in targeted advertising, especially if a company's targeting tools can actually help you engage in civil rights violations? Is the line where a company auto-generates pages for terrorist content and actually creates those pages themselves? Is the line when a company's tools actually connect a perpetrator of a crime with a victim? I'm not saying we have all the answers to that, but that's the conversation I want to see have instead of a conversation about content moderation. And I'll just say 2 last points. I'm sure any of us here could talk for a full hour about this first question. We hear so much, it's just too hard. It's too hard to define what all that looks like. Or it's too hard to address these issues, companies will get buried in lawsuits. We heard the Supreme Court start to quibble over what's an algorithm and what's a this. A lot of that conversation is actually meant to help us think it's too hard and therefore we should remain with the status quo. And I think there's some very specific examples I hope to go into on this panel that will show where Congress could play a role in updating these rules.
I'm Matt Peralt. It's a pleasure to be here today. Thank you so much to Tim and others for organizing this wonderful event. I think before I get into some specific ways to think about 230 reform, maybe I could just start with an observation. And the observation is that in the conversations like this one, which I consider to be sort of expert conversations with people who know the internet, though the substance that is proposed as potential options for reforming Section 230 typically look very different than the substance that has actually been proposed in Congress. So if you look at the reform options that have been proposed, I think there's a dichotomy between what you'll probably hear today, or you'll hear at lunchtime in your networking lunch, from people who work in the field, and then what we're seeing on the Hill. In our preparation conversation for this panel, I made that statement, and I thought of it sort of, I guess, in the typical sense of sort of a way to be critical of the knowledge that exists on Capitol Hill and in the administration around formulating solutions to this issue. As I sort of thought about it more, I guess I mean it more actually as a critique of us in this community, in the expert community, for failing to come up with solutions that are responsive, not just to the substance of the issue. So I think all of us have thoughts about how to be responsive to the substance of the issues. That's the driving force, I think, for what our recommendations might be, but also responsive to the politics. And so we're looking, I think, for solutions that will create a better internet that are both responsive to the substance of the issue and then also responsive to political concerns that people have. I think the failure to reform this area is probably due in part, I think, to inadequate solutions that are responsive to both of those considerations. So now I will give you a list of 5 things that I came up with that I think are inadequate, it seems like, to the political concerns because they've gotten zero traction. So the first is reforming federal criminal law. So as Barron said, I think in his comments, federal criminal law is an exemption to Section 230, so you can initiate a case against a provider under federal criminal law. A platform cannot use federal criminal law as a defense in that case. That means for many of the concerns, or at least some of the concerns that we have about speech on platforms, 230 is not a defense. So if we had a law on voter suppression, for instance, we don't actually have a federal criminal law on voter suppression. If we had a federal criminal law on voter suppression, Section 230 would not be a defense. The law governing the use of communications tools to riot was passed in the late 1960s, has not been updated since then. That is a federal criminal law. Though if you file a case using that federal criminal law as the basis for it, Section 230 is not a defense. So Congress has options available to it to look at things that we think are problematic and pass federal criminal law in this area. 230 wouldn't be a defense. And that would shift intermediary liability for platforms and also enable us to go after perpetrators more effectively. A second option is to focus on the differentiation between an interactive computer service and an information content provider. An information content provider does not have 230 protections. The language in the statute is develop content in whole or in part. So what does develop content in part mean? There's been very limited jurisprudence, I think, on this question. I think this is a little bit of what the court was going back and forth on last week. And I think more robust development of that line would be very helpful. There are others, I think, in this audience who understand a little bit more about the types of policy tools that would be available for setting that line. Various different things like advisory opinions or policy statements by the FTC, for instance, I think are ways to explore what the criteria might look like for delineating between those two components. A third is looking at product tools that would actually identify perpetrators. So platforms can actually build tools to enable law enforcement officials to go after perpetrators of illegal content more easily. That would mean reporting mechanisms to state attorneys general, for instance, or reporting mechanisms to nonprofits who might help individuals to redress harms in different ways. That doesn't, 230 is not implicated in that. That is platforms facilitating individual liability more effectively. A fourth, which has been talked about in lots of contexts, is researcher data access, so that we actually understand more about harms that exist on platforms. And then a fifth is, I think, an idea that I supported in a paper I wrote on it was some version of the PACT Act. There are, like, I think a lot of people in the first panel were sort of talking about that as a viable model, perhaps with tweaks at the edges. I included this recommendation in the paper, and I think it was an example, actually, of a bias that I had because of my prior employer. So I was on the policy team at Facebook for several years. And the stuff in the PACT Act seems kind of unobjectionable, I think, from the perspective of a large company like Facebook. Regular transparency reports, someone on staff to process complaints about illegal activity. For a large platform, that's very routine. You have huge legal teams, huge policy teams, huge communications teams that can handle that type of volume and process it. In the wake of this paper, I got a lot of feedback from companies like Reddit, for instance, so I'm excited to hear what Billy will say about this, that is really biased towards large platforms, that smaller platforms would struggle with the kinds of requirements that are in the PACT Act because they increase compliance costs, and for smaller platforms, increased compliance costs makes it more difficult for them to compete. So, Billy, over to you.
Great, wonderful. What a segue. So what I really wish Congress would do, since 230 has become this political football, is let's put the football down for a second. Let's take a few steps back. Let's just ask a few questions. What are the specific problems we're trying to solve as a policymaking body? What are the harms, the specific harms we're trying to mitigate? And what populations are we trying to protect? And once we have nailed down those framing devices, let's try to figure out what's the best way to solve that. What's the best way to directly respond to those issues? And spoiler alert, like, in the opinion of the Reddit policy team and ourselves as a company as a whole, we think there are a slew of policy options that Congress has that more effectively answers some of the questions that have been brought up in this panel so far, right? When it comes to issues like we've heard, Joe mentioned the concerns about conservative censorship. We've also heard about transparency, access to research data. There are other ways that we can sort of deal with these issues beyond using the blunt instrument of 230. And the other thing that I just want to know, because I don't want to hold us up, there's so much more for us to talk about here, is whenever we limit laws that make it easier for people to engage in speech, make it easier for users to create communities or find communities that serve them content or connect them with other people, that make them feel welcome and inclusive. When that happens, there's a blast radius. There's going to be less speech in other areas. We saw this with Sesta Fossa. We've seen this in other sort of proposals as well. And I just really wish that Congress would keep that in mind, what the impact will be on the internet generally and on users specifically. And that's the sort of thing that we tried to highlight when we submitted our brief to the Supreme Court regarding Gonzalez versus Google, by empowering our users to speak about how their specific communities would be impacted if Section 230 was limited. But with that, Rebecca, go ahead. I know you have some fine questions for us.
Well, I mean, you guys are doing a great job. I guess I wanted to talk about Sesta Fossa, because it is the one time Congress has taken the scalpel and cut back some of 230 protections with the intent of, the good intent, noble intent of stopping sex trafficking. It has some unintended consequences of putting sex workers potentially in dangerous situations. So I wanted to use that as a jumping off point. What kind of lessons can we learn in this community of experts so that, to inform Congress to not make those same mistakes. Because as you were saying, every proposal has its unintended consequences. So is there a way to educate Congress, or is there a specific issue that you think could gain bipartisan traction that would maybe avoid these negative consequences that you're imagining?
So 2 things. First, I'm going to break that down. The lessons with SESTA-FOSTA that I think Congress could learn, and other issues that Congress could sort of focus on that are related to CDA 230. When it comes to SESTA-FOSTA, what does it mean to engage in a venture related to child sexual exploitation? Courts seem to have a hard time figuring that out. Like, this law has been too vague to be enforced appropriately in a lot of ways. And I mean, no offense to Joel, love you guy, but the GAO report demonstrated some of the failures of SESTA-FOSTA to be used effectively in the way that lawmakers intended. I think the key thing is, if you're going to write a law like this, let's make sure that everyone on down, whether it's policymakers, judges, prosecutors, and of course, companies themselves understand exactly what the impact will be and how to stay out of potential actions that could get them into liability. With Reddit specifically, there were sex worker communities where people were just simply talking about how they have been impacted through sex work, not engaging or asking for sexual favors or whatever. And we had to shut those communities down because there was no way for us to know particularly what the line was. And so I think it's really important, if Congress decides to engage in this sort of stuff, that there is a clear fault line between liability and protected speech.
Can I respond to that?
Yeah, sure.
So, and Billy, the love is shared. But I think that to limit this to first, I hope we get beyond SESTA-FOSTA today. Yeah. But I think to limit this to, hey, Congress messes up when they write laws, and judges will interpret because that's what they do, is what got us in this issue in the first place. I mean, whether you're talking about the judge-made immunity or the vagaries that exist in Section 230 are always going to be a problem. So I think to say, to simply, and I hope I'm not asserting something that I hope I'm not misrepresenting what you're saying. That's fine. But I think this sort of is hearkening back to a more libertarian view, which is like, let's not touch it because bad things can happen. I think that's absurd. I think even from a political standpoint, that's just not the reality. I mean, if you really want to do this, I do believe that you can take targeted approaches. You can do something incrementally. And I think that's something that is bipartisan, is this relationship between the concentration, the significant concentration of information with a select few corporations that kind of control how we think through the discourse. If you want to if you're really worried about small businesses, and Billy, I'm speaking to you here, then maybe there is an opportunity for Congress to outline exactly what type of company you're talking about. And maybe, and I agree with you, maybe there should be some clarifications in SESTA-FOSTA, but to say that it was categorically bad is not true. I mean, I do think that there was a really good outcome when Twitter was held accountable for not taking down basically what was revenge porn on children. I think that was a good result that ultimately allowed the case to move forward and didn't let Section 230 to be an immunity. Again, I think I agree with you, Billy, that we should articulate the goal. However, I don't think that we simply poo-poo the entire idea because there's a few courts that may have some bad interpretations.
Yeah, can I pick up on that, actually? I, too, do not want this whole conversation to be about SESTA-FOSTA. That said,
Maybe like Sesta Fiesta.
Yeah. That said, listen, part of that we can't solve in this conversation, and part of that is just how inflexible our lawmaking and policymaking regimes are to begin with, and that's just not what this panel's about. But I mean, one of the lessons is that we probably need a more flexible way to not just consider lawmaking, but consider how to be able to update as we get more and more data about how the enforcement of the law is going. But that aside, I think one of the things, so we at ADL, as I said before, we focus a lot more on platform behavior. Yes, we obviously, our mandate is to look, especially for the Center of Tech and Society, is to look at the proliferation of hate and extremism and harassment online. But one of the other lessons is, what are the things that we can look at, again, more that focuses on conduct and behavior of the company versus on whether or not they are engaging in the right kinds of content moderation. And I'm gonna give you one sort of specific example, which I alluded to before. So many of you in the room are probably familiar with the fact that, Facebook, also where I used to work, so I think we both have a bit of a different view on this, but Facebook advertising, in and of itself, they continue to use Section 230 as their excuse to not ever be held accountable for any of their own targeting tools. Now, Facebook's targeting tools, let's look at the cases about discrimination in housing and jobs, right? So yes, you can say that the advertiser should be held responsible if they are going to purposely exclude a group based on their race, their age, their gender, from seeing housing ads or from seeing job opportunity ads, which we know is a civil rights violation. But would you also argue that Facebook, whose own targeting tools that they have designed and monetized, are what is allowing that advertiser to discriminate based on age, race, gender, should that also be immune under 230? And then many people, when I engage in that conversation, they say, oh, but that case was settled. The case being settled does not mean that the question has been settled, because those cases are still ongoing right now. And Facebook continues to assert that Section 230, just because they settled, doesn't mean that they don't still say Section 230 should immunize them, not just from the fact that their targeting tools allow this kind of discrimination, but yes, even when the advertiser themselves is not necessarily checking the box to discriminate, Facebook's targeting tools sometimes is doing it itself. And I'm just going to point that there is a person in the back of the room who is actually prosecuting these cases. So if you don't believe me, please go speak with Peter later. These are legitimate things that Facebook continues, and I get it. Section 230 affects Reddit, it affects smaller platforms, but Reddit is not engaging in selling targeting tools to allow you to actually discriminate in violation of civil rights. And so those are the things that we want to focus on more.
I agree entirely with Yale's first point about the inflexibility of the current policy process. I think SESTA FOSTA is an example of two failures. One is substantive. It was designed to protect the sex worker industry. The sex worker industry is now protesting for its repeal. That, I think, suggests that maybe the law isn't performing as its proponents hoped it would. But I actually think that's maybe like the less important concern. I think the most important concern is the one that Yale referred to, which is that we have, for some reason, a model in our public policy system that we pass a law on day one and we just hope it's going to do really well, it's going to perform really well in practice for the next 20 or 30 or 40 or 50 years. I think Section 230 has performed unbelievably well, but it was passed in 1996. That is held up as well as it has, I think, suggests that it was a strong law at its creation. But the world is different, and it probably suggests that it could be tweaked, at least at the edges, if not dramatically shifted, to reflect the world we currently exist in today. We don't have a policy regime, for whatever reason, that enables us to experiment with public policy, to incorporate learnings from how public policy tools perform in practice, and then improve a policy regime over time. There are a lot of people who are critical, for whatever reason, of the idea of experimentation in tech policy. And it doesn't quite make sense to me because we believe in experimentation in other fields, including fields that I think are more important and have more life-death risk than tech policy. We would not have, I don't think, vaccines today at all. We wouldn't have a COVID vaccine, for instance, if we did not permit medical trials, because medical trials enable us to test whether medicine works, if affect a range of different potential harms, and then tweak the medicine in light of what we've learned in the course of a trial. The absence of that kind of mentality in tech policy, I think, does a few different things. One, it means that we have to try really hard on day one to get it right, because if we don't get it right, it's going to be on the books for 40, 50, 60 years. I think it's going to be incredibly hard to repeal SESTA FOSTA because of the politics of it, even though I think there are a lot of people who believe that it's a bad law. And it also just means that we are unable, it means that there is a high political bar to passing any reform in the tech sector, because we know that anything that we do is going to exist on the books for a long period of time in the future, and that means we need a certain amount of political capital that I think is an immense amount of political capital to get anything done. If we had more of an experimental model where we pass a law that might exist for 12 months or 18 months or 2 years, we enable researchers to gather data on how that law is performing in practice, and we have some mechanism then for incorporating that data into the policy process at the end of that trial period, so we can improve policy in the long run. I think that would be ideal. Even in rooms like this, filled with people who are brilliant in this field, I sort of think that it's possible that most of us don't really know how this stuff's gonna perform in practice. We have our hunches, it's informed by a lot of different things. We have our beliefs about, based on our own experience about how something's gonna perform, but we don't really know. And an experimental model in tech policy would enable us to test our assumptions and then to improve policy based on what we see in reality.
Yeah, I'm glad that you mentioned the fact that Reddit has a different sort of model when it comes to advertising, right? We mostly target users through their interests, right? If you follow the r/soccer subreddit or r/cats like I do, you're probably going to get products related to that, right? So that is a differentiation regarding platform behaviors. And something I'm not going to ask you this, maybe over drinks sometime. I am interested in why CDA 230 has to be the method through which we needle out the sort of insidious platform behaviors or problematic platform behaviors. Sometimes it's the only thing. We might assume that might be the only way to do it, but I wonder if there's some other ways that we can sort of experiment and deal with those sorts of issues that doesn't use this particular statute because of how it impacts our users. And then the other thing I'll just note quickly, Matt, I've read your policy proposals. I think they're very interesting. The problem is whenever I look at my bill tracking list of what's going on the state and federal level, right? It does not reflect the sort of, we're gonna stop and see and do a lot of experimentation based on data, right? That's just not how it tends to work. There are a couple bills that I think.
That's the issue. It tends to work poorly, right? So we don't have a model. We have models in all other parts of life where we test and we use those tests to inform our policy regime. Other countries have those models. There are regulatory sandboxes and jurisdictions all throughout the world. Why can't we have that in tech policy? I agree entirely that we don't, and I agree entirely that proposals that many of the folks in this room have introduced and thought of as the right proposals in this field don't get political traction because I think they're not responsive to the politics. But I think the issue is that we have a framework set up where we have to have certainty on day one that a thing is going to perform in practice as we say it's going to perform, and that introduces just an unbelievably high standard for lawmaking that I think doesn't work in a world that's moving as quickly as the tech policy world is.
Do I have to wait for drinks to answer Billy's question, or can I answer it here? Because it actually takes us into the next topic, right?
Yeah, sure.
So listen, I, before I joined ADL and currently have never argued that Section 230 is the end-all be-all one thing that will fix the internet. It is one piece of a larger puzzle. And that's another argument that some people, and I'm not saying you at all, when I say some people, assume I mean my former employer, that some people like to use to shut down the conversation, right? At the end of the day, this is still the only industry that benefits from a protection that no other industry benefits from because we wanted technology to flourish, because now technology is too hard for us to all understand. And so no matter what, including all the other laws I would love to talk about, Section 230 still does. It has been so overly broadly interpreted. So to me, it's not actually about whether we should completely amend how it is written. It is about how has it been interpreted to this date to just be used to throw out cases before a victim has any opportunity to even get to discovery, to even start to learn, to your point about being able to learn to reform our entire process, whether or not that platform did play a role in facilitating that harm. And that is one of the things I cannot continue to understand how as a society, which one of the principles here is that a victim is supposed to be able to face the person or the entity that helped commit a crime and have their day in court. And 230 has been so broadly interpreted that that has just become a huge barrier. But I would say there are all sorts of other things. One of the reasons that we have been fighting so hard for some of the transparency laws, like AB 587 and others, is because part of the conversation we're having today is based on assumptions, because we have no true insight into how these things actually work in these companies. And to this day, we continue to rely on companies to self-report, and that is what we are using to write our laws. So we don't believe in transparency for just transparency's sake. We want to see true transparency in how platforms' own tools are being used, how their policies are being enforced. There are some other ideas of transparency out there that we fundamentally disagree with. For us, it's about getting insights into where these companies' own rules are, how they're enforcing their own policies, so that we can write better laws, so that we can enact more data-driven policies. So to your point, Section 230 is not the end-all, be-all only thing, but it is the law that has enabled platforms. I know when I worked at Facebook and I tried so hard to get a voter suppression rule passed within the political advertising system, which was easy. We had it all worked out how it would be done. They said no. Anyone who knows my story knows that's why I left. But they flat out said no, and I believe it's because there was no incentive for them to do the right thing, because they don't have to. So while Section 230 is not the one thing that fixes the internet, I will continue to say we can't just push it aside for all these other laws that we hope to get passed, because it still enables truly bad behavior by some companies, and that is something we need to address.
And yeah, I just want to respond to that. Because I think you're absolutely right. I think that there are tweaks that you can make to Section 230 that make perfect sense, and things that are getting currently debated. I think earlier to a previous panel, I believe it was Matt Wood who was describing this question of distributor liability versus publisher liability. That is something that should actually be articulated in some way. And I see your grievance, Baron. I know, I see you there. But but I mean, it is a legitimate concern to not only address from a legislative perspective, but also to be very clear as to what publisher liability actually means, or what the words mean in the text. Because to speak directly to Yale's point, I mean, this is precisely why C1 is a problem. C1 is a problem because, frankly, most all civil liability can basically be thrown away because, we can't discern whether this is they're acting as a publisher at one instance, and then at the same token, later down in their own brief, they say, actually, we're a distributor, so that this doesn't really matter. So I think that this level of conflicting notions are something that, maybe Congress should take up and maybe discuss more intuitively. Other thing, you talk about C2. That's where you get to one of the censorship issues. Like, there are legitimate things that have been thrown out. And I know this is the moment I say this, everyone's going to groan. But I think truly, if you want to look at how the statute has been interpreted to allow for this type of moderation, I think you really look at how courts have just have read this in such an overbroad way, where they can basically just take down, or they can take down whatever they want, whether it's, if you're a Republican, you're really concerned about the COVID vaccines. If you're a LGBT person, then you're really worried about all the stuff that they take down from the perspective that they are not liable for doing any of that because they're actually, quote unquote, encouraged to do so. Well, okay, then a reasonable take is put up a public accommodation onto that. So that way no one can get taken down for those particular, or they don't at least get those immunities if they violate some form of public accommodation. And that could include political affiliation, that could include gender identity, that could include sex, all the traditional things that you would get from a public accommodation. It makes perfect sense. And I think anyone who worries that, that's too broad or that's too, well, look, you guys seem to be very big fans when the court actually rules your way. Maybe try your hand there, because ultimately I think the courts will get that right if they have a framework. Right now they do not have that framework, so maybe it's up to Congress to give them that.
Well, so this week, Congress will have a hearing. The Senate Judiciary Committee is going to have a Section 230 hearing in the wake of the Gonzalez v. Google case, which we had the previous panel on discuss. What we expect will be discussed will be the Earn It Act, potentially the Safe Tech Act. And I just wanted to see if there are some provisions of those bills or current legislation that you think could thread a needle on some of the issues we're discussing right now? I mean, Earn It has not been reintroduced. It will be, though. So, and it is Blumenthal's subcommittee. So.
I mean, on Earn It, my sort of view of this has always been that this is an issue on the enforcement basis more than any sort of 230 question. One of the things that we've sort of supported as a company is, well, actually, I think it's probably the only bill that we've endorsed is the End Child Exploitation Act, which was introduced by Senator Marsha Blackburn, which would allow companies like ours to hold evidence related to CSAM cases up from 90 days to 180 days, so that we could assist the relevant authorities with that information as if investigations go on for too long. Because there have been times where we, by law, are not able to keep that evidence for long enough to assist them. But also, there's other bills out there that deal with the enforcement side of this and the prosecutorial side of this. Senator Wyden's Invest in Child Safety Act, which provides $5 billion of funding to NCMEC, the Department of Justice, and creates an office in the White House to coordinate efforts agency-wide against CSAM efforts. So quite frankly, I think that's more effective than what's in the Earn It Act.
Then altering 230 for that.
I mean, we actually have we're quoted in the release for the Safe Tech Act, so I feel like I should at least bring that one up. Listen, like with many of the laws as written, we agree with the spirit of it. The problem is when you get down to really how it will be enforced in the actual details, right? Like, just one of the things in the Safe Tech Act is, can we start differentiating between what is information and what is speech, right? So that's going to be, that gets back into the content moderation side, which I said is actually not my prime focus, so I realize that that is opening up a whole Pandora's box. But we do think that some of the act, sure, it needs to be refined and the wording needs to get more specific, like they talk about paid advertising. My issue with paid advertising also falling under the same rules is not when it's just paid advertising. It's when it's paid advertising that gets to benefit from targeting tools that actually are part of, I hate to throw out the term surveillance capitalism, but the surveillance business model, right? It is, should that company who is not just showing you an ad, but is actually allowing that advertiser to target you based on more than just because you like cats, but because of age, race, gender, because you liked this particular thing, we're showing you this, which might be cats, but it might also be like the Facebook whistleblowers paper showed with that story about Carol's journey to QAnon. It might also be you liked this person, and within 2 days, we're going to start showing you and pushing you into QAnon groups. Like, that's not advertising, I get it, but some of the Safe Tech Act tries to address some of this. There are definitely some ways that it will need to be refined, and the problem is it's going to be how is it enforced. But I think we're too easily trying to throw out every single idea on the Hill because, to Matt's point, the bar for it has to 100,000% not have any trade-offs, otherwise it breaks the internet. I mean, every industry before tried some of that as well. Let's be frank. The tobacco industry, the automobile industry, the oil and gas industry, the food industry also did not want to be regulated and claimed that it would completely destroy them. And guess what? They all still exist. So I don't think there's that perfect bill out there. That is the bill that I'm thinking is going to fix the internet, whatever that means. But if we could get past, the biggest problem is it becomes a partisan football, and then we can't get past any of the partisan debate about it. And so I'm not really hopeful that Congress is going to go anywhere, but there are some really important principles being debated right now on the Hill that I hope have a chance to be debated.
Well, one thing that does have bipartisan support is the recognition that there are these market concentrations, and those market concentrations in relation to the information and the content distribution. So I don't necessarily share the view that it's impossible to get there. And I'm not saying you're saying that. I'm mostly just, I think there's a little bit more optimism than there is skepticism, because I think that there are going to be those trade-offs. And I think, to Billy's point, there are unintended consequences that do happen to small businesses that we do want to protect, and we do want to ensure that they don't get affected by it. So I think, and I fully agree with Billy on this, like, articulate your goal. Like, figure out what your goal is and then try to execute from there, as opposed to take a very ephemeral problem and try to, as some on the panel said, create a law that may last 20, 30 years. So I think step one, articulate the goal. Step two, execute it in a way that's consistent with, basically the harm you're trying to quell. So but again, I do think that there are elements of bipartisanship here. You certainly saw that last Congress, whether it's Earn It Act, whether it's OAMA, whether it's anything else, you are seeing a element of, we are skeptical of what these companies are doing. We are worried that they're doing things that they ought not be doing. And so I think you might see more in the line of what Yale was talking about earlier, which is transparency, because some of these larger companies have operated in almost complete opacity. So maybe that's the starting point. The starting point is start with a transparency bill and then move forward with other types of action to be more informed. But who asked me?
Matt, did you want to? To quote one of my favorite reality shows, sometimes you got to be there for the right reasons, is what they say on The Bachelor. And I worry that most of the time when lawmakers work on these 230 bills, they're not doing it for the right reasons. It's not reflective of actual issues online. Now, sometimes it is. I want to be very clear with that. I think there are some good faith lawmakers who want to deal with issues. And I'm going to prove that I'm not just casting aspersions. I think transparency is actually a really good starting point for lawmakers.
The PACT Act, or do you have anything in mind?
If I had to, I guess, caveat, this is not an endorsement by the company.
Are you sure?
Doubly sure. I'll get a phone call in 30 seconds. The Platform Accountability and Transparency Act.
Yeah.
By, I believe, Senator Coons, right?
Yeah.
I think there are actually some really good pieces of that bill. There are some issues that I have with it, but I think the starting point where they're going with it, in terms of researchers need access to data to be able, so lawmakers can target effectively the issues that they're concerned about and identify potential harms. I think that's a perfectly fine premise for policymakers to start on.
Yeah, and to switch from Congress to the states, we've seen states taking a different approach with very partisan bills, or now laws in Texas and Florida that are before the Supreme Court that would basically force carriage of speech for these platforms, and then New York passing a law basically going after hate speech, and with that as the ultimate goal, but there's been First Amendment claims that this is violative of that as well. So I know, Joel, in our prep call, we were talking about how these are both kind of colliding laws that, as platforms that are global, will basically not be able to follow both and operate, at least nationwide. So could you talk about some of the pitfalls these are creating in the state level?
Yeah, I think there's a lot of, anyone who's been around tech policy knows about the patchwork effect around privacy. And the complications that makes in terms of deciding what regulation you should potentially, follow, and what actually creates the liability, and what statute are we operating under. And then I think the big issue really is you're seeing that these states are trying to find workarounds around Section 230, which in some cases is problematic, but there are some things I actually do support. I'm clearly a fan of the Fifth Circuit. That's not a DPI perspective, but that's my personal. I think the Fifth Circuit actually had it right, but again, I think that what it really speaks to is this question of, okay, how do we want to govern these particular issues? And I think a federal strategy probably makes the most sense. And as long as we don't have that, and we have that essentially a vacuum, you're going to have states trying to fill in that vacuum in very strange ways, and in a lot of ways, very contorted ways from any practitioner who's trying to figure out, how to advise a client on when you're violating a law in Texas versus when you're violating a law in Florida or New York. So I think this is, it's probably a strong, going back to the political incentives for Congress to work, that is a huge political incentive. You match that with what's happening in the Supreme Court, with what's happening in the states, and I think you're going to actually find a lot of inroads. I think Rahm Emanuel once said, "Don't waste a good crisis," and so I think that this is what crisis that potentially could lead to a lot of bipartisan inroads for Section 230 to clarify some of these issues.
Yeah, I mean, picking up on the state strategy, which we obviously have a state strategy as well, which I mentioned earlier. I mean, part of obviously the internet has no boundaries and borders, and so obviously a patchwork of state laws is going to be extra complicated for these companies. One could argue, I'm not saying this is our strategy, but one could argue that that's sort of one of the upsides of a crazy patchwork of state strategies is to get the companies to actually come to the table and figure out what Congress could and should do. One other thing, I'm sorry, I wanted to add one point before this ends, and that is that one of the things that I forgot to mention earlier is right now, part of the problem with 230 is it's been so broadly interpreted that anybody who uses technology in any way whatsoever is held to the same set of rules. I mean, to Rebecca's point earlier, is Wikipedia the same as Facebook, and should they absolutely 100% be regulated the exact same way? Or are we at a point in 2023 that we were not at in 1996, where different companies actually engage in, I mean, I'll give a Reddit example. I read Reddit amicus brief for Gonzalez, and I saw the Reddit concern that if you start to take into consideration recommendation engines, then does that mean the Reddit user who uses the upvote or the downvote is going to be held liable? I mean, yes, I understand there are people with terrible ideas out there of killing 230 altogether. But to me, trying to equate Reddit's upvote from a user with a Facebook targeting tool that actually allows you to discriminate against people, it shouldn't even be in the same conversation. And so part of the 230 thing that is not talked about enough is what are just pipes through which information flows, and what are companies with profound amounts of power to actually cause real harm, and how do we start differentiating between some of that as well?
Do you want to respond to that one?
Yeah, I'm just going to note, I mean, that sort of, the fact that there are different algorithms and tools that are just being put in the same bucket is exactly why we submitted our brief in Gonzalez versus Google. Because some of the advocates on the other side seem to imply strongly that they believe that those tools should all be viewed in the same lens, which doesn't make a lot of sense in regards to platform behavior and how users interact with those. One thing I want to note just about the sort of state patchwork thing, obviously this is terrible for companies, right? You all know that. It's also really bad for users in a lot of ways. We've had users who have been impacted through the Texas social media law. I'm so glad I can talk about this now, because for a while we couldn't. There was a user on r/Star Trek who was banned because he insulted Wesley Crusher. I'm not a Star Trek fan, so I don't know this stuff. So that was a no-no. The mod banned him. And then the user used the Texas social media law to sue the moderator. And we were able to sort of, assist with that case in some ways, right? But like that was one of the highlights to us of, oh, this is really bad. When it's not an abstract concept that when we have these sorts of laws that essentially negate C2, right, or ban any ability for moderators to create a safer space, right, or moderate a space effectively, then what happens is moderators can be sued for frivolous, stupid decisions. And that means you're going to have less community engagement, less moderators willing to put themselves out there. And so that's what I'm really worried about from a state perspective. And also, just to be honest, like, Matt, I appreciate the experimentation point, but when you experiment, you break some eggs. And there are some negative connotations that happen with that. And I do wish that some policymakers were willing to be upfront about that. I know you would be, but
that's the point. You can't have public policy that doesn't break eggs. So you can pretend that it's cost-free. I think that's a lot of our policy conversation. We pretend that it's cost-free. You cannot have cost-free reform. So the question is about coming to terms, reconciling yourself to what those costs are, and then being prepared as a society to bear them. We learn that through experimentation. We don't learn it through jumping off the bridge and hoping for the best.
Great. I mean, we've hit our hour, so I think we've touched everything we needed to, and thank you guys for such a great panel. I appreciate it.